My name is Charles Tay of Chonglun in Beijing, and I'm very glad to be moderating this session. We are very privileged today to have a very star lineup of speakers, all eminently suited to the discussion of the Belt and Road Initiative. Two of our speakers are from major Chinese companies, state-owned enterprises, Sino-Hydro and China National Petroleum Corporation, and two are very distinguished lawyers. First, let us start with introductions. First, for the representatives from the companies, we have Mr. Peng Shening, who is General Counsel and Chief Compliance Officer of Power China International Group Limited. Power China is also known as Sino-Hydro, and he has held positions as contract manager and project manager on quite a few mega projects outside China since 1990. And in the premises, he has more than 30 years of experience, and he is very experienced and interested in the life cycle management of contracts, conflict avoidance, claim settlement, and dispute resolution. We also have with us today Mr. Zhang Fan, who has been working with the CNPC Group, that's China National Petroleum Corporation. Otherwise, and its international arm is known as PetroChina International Company Limited, and he has been working with them since 2004. That's 17 years ago. And since he joined CNPC back then, he has seen CNPC undertake its global expansion, and he has participated as main member of its negotiation team and legal counsel in a number of important oil and gas projects across the world, including the China-Myanmar oil gas pipeline, the China-Russia Eastern Pipeline, the China Central Asia Pipeline, and many other related contracts and projects. His many years of working experience grant him a deep understanding of legal risk control in the oil and gas industry and in how to build contractual structures that balance risk and benefit. Next, I will introduce the lawyers, and we have first up Mr. Sun Wei, and he's a partner of Zhonglun Law Firm, one of the Red Circle firms in China. He is qualified to practice in the PRC and in New York, and he holds 2 LLM degrees from New York University as well as the SOAS University of London. And he graduated from his bachelor's at the China University of Political Science and Law. He is a panel arbitrator of many international arbitration institutions, including SIAC, HKIC, TIAC, of course, and many CTAC and many other institutions as well. He holds many positions, including the position of Secretary General of the Permanent Forum of China Construction Law. Mr. Sun has extensive experiences in construction, energy, finance, corporate, equity, and real estate, and he has represented clients in diverse jurisdictions such as the US, Singapore, Hong Kong, Germany, Austria, Qatar, Bulgaria, Iran, Vietnam, Peru, and many other countries. In 2019, he was nominated as the Best Development of 2019 for GAR for his role as the first emergency arbitrator in mainland China. Finally, last but not least, we have Ng Zhenfei QC. And Zhenfei QC has 18 years of experience appearing before courts and tribunals and sitting as arbitrator across many different jurisdictions such as England, Hong Kong, Singapore, Malaysia, BVI, the Cayman Islands, and Luxembourg. He has acted as counsel in some 350 cases and as arbitrator in more than 30 cases involving rules under the ICC, HKIC, LCIA, and many other institutions. In 2018, he was one of the youngest persons to be appointed as Queen's Counsel in England. Today, he holds the distinction of being one of only 2 ethnic Chinese QCs in the world. Legal directories describe him as one of the most talented counsel on issues of strategy, and he is extremely intelligent and tactically astute. With such distinguished panelists here with us today, we have 1.5 hours for this session to discuss the Belt and Road Initiative. The session will be divided into two parts, and in the first part, we will invite speakers from the companies to introduce their respective businesses and their experiences with Belt and Road projects, risks, and issues. Following which, we will have the lawyers provide their comments, observations, and thoughts. We anticipate that this will take about 40 minutes, and after that, we will move together into a roundtable discussion where together, all of us, we can expand upon our discussions about the BRI and its issues. If anyone in the audience, whether offline or online, has any questions, please feel free to raise them. Those online can raise them in the chat box. Those offline, I'm sure there's a system for you to do so. And so without further ado, I would like to invite the representatives from the companies to join us in introducing themselves and their projects. First up, can we have Mr. Chang, please, from CNPC PetroChina?
Hello, everyone. This is Jonathan from PetroChina International. Our company is acting as a trading and international investment part of CNPC Group. And we've been working with our counterparty in Central Asia for many projects, such as Central Asia Pipeline and China-Russia oil gas pipeline. I think we also have several cooperation with the counterparty in our Central Asia countries, such as Turkmenistan and Kazakhstan. Today, I think I will identify some of the issues that we've been encountering during the cooperation with our counterparty in Central Asia. I think the first part I will share with the professionals here is that I think that this one is the tax issues. I think lots of our colleague from other country were also facing those problems. When we sign contract, we are actually on the circumstance that the tax is not quite, I would say, not quite stable for us. Because when we do the due diligence, when the project started, when we do the due diligence, the tax rate is like 3 or 4 or 7%, a certain percentage. But after when we come into the operation of the project, the tax will change. And also some tax authority will impose some of the tax on the product with the principle that we probably cannot understand at all. So that creates lots of uncertainty for us during the operation of the project. That's the first thing. And second thing I think we face the most frankly is that there will be a government act that would impact our performance of contracts, such as the government will suddenly announce some of the state they will need more energy, so that we have to cut off your supply, something like that. That will create that actually our counterparty will say that's a force majeure to them, but we will say, okay, your Companies Act, you actually can predict that, because during the winter, we all know that during winter your supply is definitely will short. So you can predict that, but you should be prepared for that. You can't just move that risk to us. But that things frankly happen to us, and that actually creates lots of supply short problem for us. So that I think the second things we think is a big problem, and that's the main issue that we've been facing in our Central Asia project. And if you look globally, and the Belt and Road BRI project, I think they always facing 3 main risks. First one is a price fluctuation. Second one is the low stability And the third one is the compliance issues. I think we will probably talk about a little bit detail when we hit those points during the event. Okay, that's all.
I think I was on mute. Thank you very much, Mr. Zhang, for sharing. Could we now perhaps invite Mr. Peng to share as well? Mr. Peng, I think you are on mute. I can't hear you. Hi, Mr. Peng, sorry. I still can't seem to hear you. Perhaps could we try adjusting your settings?
Can you hear me now?
Yes, we can hear you now.
Sorry. Maybe because of this headphone. Power China, as Charles just mentioned, succeeded Sinohydro in 2014. So in this sense, Power China can be traced back to 1950s, with initial main business being hydropower development and water resources harnessing and conservancy. And present, Power China's business expands to other areas like road and bridge, railway, airport, housing, etc., covering the full supply chain across planning, financing, design, manufacturing, procurement, construction, O&M. Now, Power China has a total staff of about 200,000, and we have six regional offices covering the whole world. And we have now an annual turnover about $83 billion US, and with an total assets about $164 billion US. Power China actively participates in the BRI. Now, out of the 65 BRI countries, we have offices and subsidiaries in 47 countries, and we operate and perform contracts, about 2,000 contracts in 48 BRI countries, with a total ongoing project contract value about $10 billion US. So regarding the risks we are facing in these countries, I fully agree with Mr. Zhang, the three categories, but maybe we can discuss this in detail when we come to next session, slot. Thank you. And that's all from me.
Okay, thank you very much, Mr. Peng, for your brief introduction about your company, as well as some of the business that you do. Perhaps now could I invite some of the lawyers to come and provide some comments on what has been shared. Could I invite Mr. Sun, please?
Thank you, Charles. My thought on this is threefold. First, geopolitics has greater influences in foreign investment than ever before under the current international relation dynamics. Geopolitics conflicts caused some projects contracted by Chinese companies to be cancelled. Second, Chinese companies also gradually have a strong sense of employing international commercial arbitration and the investment arbitration to safeguard their own rights and interests. Third, Chinese lawyers are playing an increasingly important role in international dispute resolution. So that's my thought on this. Thank you, Charles.
Thank you very much, Mr. Sun. Perhaps Mr. Ng, John Fei, could you add some comments?
Absolutely. Well, first off, thank you very much, Charles, for the very warm and generous introduction. A very good morning to you all, ladies and gentlemen, participating online as well as on-site from Tashkent. It is a pleasure and privilege to be able to address you all on the second day of Uzbek Arbitration Week and to be able to share a platform with so many distinguished panelists and speakers, Charles, Mr. Peng, Mr. Zhang, and of course, Mr. Sun. I listened with great interest, in particular, to what the three speakers before me had to say. And what I'd like to focus on in my initial remarks is really to focus on something that Mr. Sun had said, which struck a chord with me, which is about the mechanism by which disputes between investors, and I suppose in this case, Chinese investors and their host states can be resolved. And secondly, to grapple head on with what I thought was a very incisive observation that Mr. Zhang made, in which he singled out the changing national tax regime in a host state as being perhaps one of the more pertinent and worrisome at times contributory factors to the stability of an investment. And there has been some recent judicial and legal developments on that regard, which I'd like to focus on. But dealing with the first of my twofold focus and addressing the system of dispute resolution, very often in many cases, particularly those with a BRI element in which I am involved in, where you have a Chinese party on the one side and perhaps a non-Chinese party and or a host state in one of the many BRI jurisdictions on the other. Very often what I find is that a compromise is struck in terms of determining the seat of any dispute resolution, the mode of any dispute resolution, and the governing law. And the compromise that I typically encounter in many of the cases in which I am involved involve arbitration as opposed to court-based litigation as the preferred mode of dispute resolution, with a seat in what is perceived as a neutral jurisdiction, i.e. not one that involves either parties to the transaction, commonly where the investment involves an Asian country. The most popular seats to my mind are Hong Kong and Singapore. And this tends to be, by and large, the compromise that is struck by the two parties to a contract with a BRI element. So far as governing law is concerned, there has been a change in trends. Now, if you had asked me this question sort of 10 years ago, and you were to ask me, what is the system of law that parties with a BRI element tend to opt for in their contracts, I would have told you that the overwhelming majority of it would be some common law-based legal system. So we are looking at Singapore, Hong Kong, or English law as being perhaps the most common and popular options which are chosen in these contracts. However, increasingly, and perhaps this is a reflection of the strong and increasingly growing strength of the bargaining position of the Chinese parties in such contracts, where the compromise is typically struck in circumstances where perhaps in acknowledgement of the fact that the seat of the arbitration where disputes are to be resolved is going to be in a jurisdiction that is not in mainland China. The compromise I have seen increasingly struck is that PRC law is selected as the governing law of the contract. That being said, other oft and well-worn alternatives such as Hong Kong law and Singapore law remain popular. So what we are beginning to see is an evolution where in terms of the governing law, there is a better spread of legal systems which are selected as the governing law of the contract. And the three most popular options to my mind remain Hong Kong law, Singapore law, and PRC law, not perhaps necessarily in that order. And what this leads is to, if and to the extent that disputes do emerge, such that there is a need to refer the dispute to arbitration, I have seen a more blended, perhaps more, I could say, multinational team representing whether it's the Chinese party or the non-Chinese party in the arbitration. So you see a combination of PRC law firms and or international law firms and or independent counsel like myself, representing either the PRC party or the non-Chinese party in these disputes. So that is what I've observed in terms of the emerging trends of dispute resolution for the purposes of resolving some of the thorny problems that both Mr. Zhang and Mr. Peng have identified. Now, one of the perhaps more topical and significant problems to emerge of all of that was what Mr. Zhang had alluded to, which is tax. And those of you who are, like me, perhaps involved in the world of international arbitration may know that late last year, a permanent court of arbitration, a PCA tribunal in The Hague, ruled in favor of Vodafone in a treaty arbitration claim, which it brought against India in respect of the retrospective imposition of tax, interest and penalties by the Indian government on Vodafone. And there is a separate case which has been brought by Cairn Energy and Vedanta Resources against India, in respect of this retrospective imposition of tax. The PCA tribunal in The Hague held that retrospective imposition of tax was a breach of the fair and equitable treatment standards in the bilateral investment treaty, to which India is a party. And that, to my mind, apart from what is perhaps more de rigueur, commonplace commercial arbitration, is an area to focus on, whether you are the Chinese investor or perhaps even from the position of the host state, because it is important, obviously, where if you are the Chinese investor, to be aware that there are opportunities for you to bring treaty arbitration claims in parallel to, sorry, not in parallel to, but following any commercial arbitration claims that may be brought in order to safeguard your investment against retrospective and unfair and unequal imposition of tax. Similarly, if you are, the same applies if you're an Uzbek investor or a Russian investor, obviously the arguments apply by parity of reasoning. Conversely, if you are the host state, then there is a need, obviously, to be aware that the imposition of tax, retrospective or otherwise, and other measures. So, for example, one of the other things that Mr. Zhang said, which very much intrigued me, was the idea that a host state could perhaps, on an ad hoc basis, change the composition of the composition of the gas supply arrangements in order to suit domestic needs, and that might, in and of itself, run afoul of bilateral investment treaty obligations. So those are my initial observations and contributions on the very interesting problems which have been identified by the other speakers before me, Charles.
Thanks very much, Junfei, for your very insightful comments and your clear, extensive knowledge about the world of investment arbitration as well as commercial arbitration, and in terms of the many risks that can occur during the course of a BRI project, whether that involves a Chinese investor or an investor from another country. Do any of the other three panelists have any comments in response to what Mr. Junfei has shared? If you do, please be welcome to share. if not, we would move towards our roundtable discussion where we would expand upon the issues that we have talked about.
Charles, I think I have thoughts on stability clause, which is related to taxation problem. But I think I'm going to discuss that at the topic of policy risks and political risks and many other things.
Okay, thank you very much, Mr. Sun. So perhaps now, I suppose, would be a good time for us to start to move to a more open-ended format of discussion, where I would pose certain questions to the panelists, and the panelists would, based on their many years or their many decades of experience working with projects around the world, be able to comment. So for today's session, it's titled Belt and Road Initiative, Current Challenges and Future Prospects. So I in terms of current challenges, there are many challenges that would come into play when parties from different cultural backgrounds, from different parts of the world, different legal backgrounds enter into cooperation. And I suppose on this topic of cultural differences, this could be a good starting point for discussion. So cultural differences can come into fore in many different stages of a contract. Junfei QC and the panelists have talked about projects about risks that can arise after the commencement of an investment. However, the projects start long before that, and even in the pre-contract stage, these differences can sometimes be interesting and can give rise to issues. And so my first question is to Mr. Zhang. How, based on your experience, do you bridge cultural differences when it comes to dealing with non-Chinese parties in negotiations, Mr. Zhang?
Okay, I think there's several points that we have to be prepared for ourselves before start negotiation with the counterparty from the other countries. The first thing I think very important that you have to understand the decision-making systems of your counterparty, so that you can arrange your proper negotiation strategies. Because when you start to negotiate, you have a mind to close it. But if you want to close your negotiation, you need to know when is the point to negotiate. To my experience, that the final point to close the deal is that you have to trade. You have to trade your position with your counterparty. So you have to make sure that how you understand how your counterparty make a decision. Is there a negotiator who have a right to make decision, or they are just a delivery boy to receive the information? After understanding that, you can have your strategy, whether you want to trade your position now and you can get your feedback right now, or you just hold your point and deliver the information to the negotiator, let them bring that to their boss, then they make a decision. So that you have to understand. Otherwise, you will face the situation where you give lots of the point out, but you receive award very less. Then you actually, in the end, you actually create a situation where you cannot balance your benefit and risk. So I think that's the first point you have to pay attention to. The second point, that you have to try your best to earn your credit or respect from your counterparty by negotiation professionally. I think that's very important. That when you negotiate with your counterparty, from our side, because when we Chinese, as a Chinese, when we negotiate our domestic contract, we actually seldomly just explain our idea very detailed, and we will not have very much reason to persuade our counterparty, because we try to, we actually have a culture to resolve all the big issue not in the negotiation table, but in the other maybe friendly, circumstance, maybe like during the meal or during a cocktail event or something like that. So, but international negotiations not like that. International negotiation that you have to be prepared with professional knowledge. You have to have very reasonable reason to back your idea and your position, so that your counterparty will feel you are a professional, you understand your business, and your arguing point is stand your position, so that they will gradually understand your point, and then they will treat you as a professional partner that can work with. I think that's the second point that we have to prepare. And the third point that is that do not want to have a contract that cover all your concerns. That's impossible. You have to consider what your counterparties think about. You have to balance your benefit and risk. You have to think, what is their co-interest? What is your co-interest? And that you have to make sure their co-interest being covered and your co-interest not lose. And then you choose a balanced point. So that, I think, is the third point. And the last point is, I think, very important. And you have to show your hospitality by preparing appropriate treatment that fit your counterparty's custom, such as when your counterparty pay a visit to your office site, you prepare the food that fit their custom. If they have vegetarian, you have to be very careful. And if they have a custom to have a break during afternoon tea, that you can arrange for them. That will actually give them a very warm, welcome negotiation experience. That actually eventually will promote your negotiation. So I think the last point is that always bear in mind that during the negotiation, that always they will have something. Maybe there's something will be changed, even if they've been agreed before. So you have to have, you can't just freak out when the counterpart say, okay, the thing that we've been agreed to, we now have to take that back. You always have to be prepared for that, because different country will have different, like I said, different country have a different decision-making system. So you have to just prior to the signing of the contract, you have to be prepared to accept there will be change. Okay, you have to be prepared if there change. So what you need to do is that if the change happens, what you're going to do. So what you need to do is that you have to prepare several strategies to deal with situation where those change happens. Okay, that's my share, Charles.
Thank you very much, Mr. Zhang. That the many points that you have shared are clearly developed based on your many experiences with different projects around the world. I see in the chat box that we have a question from Mr. Edwin Lee regarding this issue of negotiation. And the question is posed to Mr. Zhang and to Mr. Peng. And it concerns, what are your thoughts on the functions of advisors, such as lawyers, during the negotiation process? Do Chinese companies rely upon such advisors to negotiate, or do they only have such advisors assist on paper documents? Mr. Peng or Mr. Zhang?
Certainly, in the international transactions, it's always the case that we involve external counsels, including lawyers. Of course, in terms of determining the positions for the negotiation, but the advice or the opinions from such selected external counsels are also very important to build up a professional arguments in the negotiation to reinforce our positions. As Ms. Zhang just correctly mentioned, to win a negotiation, as per your planning, you have to act and perform professionally. Lawyers or other experts in your team will add to the credit of such success. Thank you.
Thank you very much, Mr. Peng.
Thank you.
For us, and I think we always will welcome to engage the qualified professional to facilitate negotiation. And I think that's I think when it's come to non-English speaking country, that's very important. And because when if we know that during the negotiation of the contract, actually the negotiation itself is not quite, I think it's not quite important. What important is what you put down in your contract word. So when we negotiate, we have lots of experience on that. When we negotiate with the language that we normally negotiate, especially in Central Asia and in Russia, we will negotiate in English, but they're not native language from both sides. So there will be some of the member of the negotiating team, they're not quite understand English, but they're quite well in Russian languages. So normally we'll in that circumstance, we will definitely engage the lawyer and technicians that they can both fluently speaking English and Russian. In that case, that will tremendously help us to understand, to accurately understand some of the important points. Because lawyer and technician, when they discuss, they will not just use English. They will use English and Russian to confirm, to double confirm that the meaning of those words is correctly expressed. So I think, come back to first questions, I think to bridge the culture difference, I think engaged qualified professional is very, very important, playing important part in this event. Charles.
Thank you very much, both of you, for your answers. Now, moving on from the issue of pre-contract negotiations to contract performance after a contract is signed. Based on your experiences, do cultural differences affect the performance of contracts involving participants from different countries and backgrounds? I'd like to invite Mr. Peng to share.
Okay, Charles. I think the answer is yes, for sure. Culture, as you know, is a series or sets of beliefs firmly rooted in the minds of a group of people or certain communities of people. It's the origin, we think, and source of mentalities and mindsets extremely difficult to be banished, and affects the way of thinking and behavior. So cultural differences, although it may have been well identified or even exhausted, of course, for us, for me, I think it's impossible to be exhausted during the contract negotiation stage, or even during the performance. It may also be well discussed with your counterparts during the pre-contract stage, and measures or responses to overcome such differences may also be worked out to cope with them during the performance stage. Yet cultural differences persist according to our experiences. Where a contract involves parties from different countries or from different backgrounds, regardless of what agreement has been concluded through pre-award negotiations. So such differences, when coming into being, take time and effort for the parties to establish a rapport and synergy, and no doubt will divert resources which may otherwise be utilized for better performance of the contract. So far as I'm concerned, the most common and critical cultural difference is language, which can be the source of misunderstanding or even conflict, hampering smooth and effective communication. According to PMI body of knowledge, communication, this skill, knowledge area is fundamental for the successful cross-border transaction. So cultural differences take other forms as well, such as designing standards, customs or traditions, etc., and may cause shocks to project participants and resistance to project progress. So when such differences exist, it is not uncommon for parties to find it hard to see eye to eye with each other. So that's my brief understanding of the cultural differences affecting the performance of contracts. Charles?
Thank you very much. There's so many kinds of issues that cultural differences can give rise to. Now, could I perhaps ask Mr. Zhang, based on your experiences in many different projects worldwide, do you find that there are any issues that are unique or special to the Central Asian region compared to other regions of the world?
I think there's three mainly, based on my experience, there's three main difference that I encounter in Central Asia regions. And when you negotiate, and it doesn't matter when you negotiate a contract or when you perform the contract, you will find that in their region they are more rely on their custom rather than international practice. Because in oil and gas industry, there's a lot of international practice that's being recognized by the industry that we've been following for many years. But when we enter those areas, we find out they have a different way to operate the project, and I think that's not a culture conflict. I would say that's maybe a recognition conflict, maybe operation conflict, something like that, because that's the things that would be counterweights, and we need a lot of events, a lot of effort, and lots of maybe persuasion work to our counterparties, and which actually increase lots of costs, and sometimes it will create some of the risk. And the second point is that the good point is that they negotiate, when they negotiate contract, actually they negotiate with very open heart. They will directly tell you that what they want and what they think, and it's very direct. They're not hiding anything at all. So they're holding different strategy that compared to the other, maybe the other parties that we negotiated with. So that's very, very good, and it's very easy for us to understand their core interests, and so that for as a commercial lawyer, that we can easily to build out our balancing contractual structures. So that will actually eventually facilitate the process of the negotiation. So that's a very good part. And the final point I think very special is like I mentioned that before. It's during the performance of the contract and even the signing of the contract, actually government actually have a lots of I would say there's a lots of power or impact on the commercial transactions, not just not like the other projects we've been dealing with. The other projects are mostly a commercial deal, and how you performance and how when you want to change your schedule, something like that, that up to the party to decide. But the project like in Central Asia, they will have lots of impact from the government. So I think based on my experience, that's the three main part. Charles.
Fascinating, Mr. Tang. Could I invite the lawyers? Do you have any views on these issues?
Shall I jump in first, Charles, before Mr. Sun does so? And I just wanted to say that there are sort of 2 points I wanted to make. The first is the point that Mr. Peng made, which struck a chord with me, which is about language. And insofar as language is concerned, very often I find in a lot of cases in which I am instructed, where disputes have emerged, that the source of the disputes tends to stem from perhaps a misperception about what the parties had agreed, or perhaps in the course of performance of the contract, which can be traced back to linguistic, i.e. language differences. And taking what Mr. Peng said and weaving it in with the observation that Mr. Zhang had made earlier on about when in the course of negotiating a contract, what really matters is what you put into the contract. That, as those of us who are familiar with the common law-based system will know, is in fact the principle pursuant to which contracts are interpreted under the common law. So, for example, English law, Hong Kong law, and Singapore law. And what is not taken into account is the pre-contractual negotiations. So the pre-contractual negotiations, what is said by the parties in the course of negotiating the contracts are, strictly speaking, under a common law governing law, not relevant for the purposes of interpreting the contracts concerned. So what really matters, as Mr. Zhang has said quite rightly, is the text, the language that is used in expressing the contractual terms itself. There are, however, there's one exception, and there's one practical advice which I would give to those listening in or watching our proceedings today. The first exception I would say is that where you are dealing perhaps with a situation in which the language that has been used in the contract does not accurately reflect the common intention, the mutual intention of both sides, which is, I suppose it might be said, a problem that is particularly acute, where the first language of both counterparties is not English. And let's say the contract itself is expressed in English, and therefore there is a chance that the language that both parties have used to express their contractual obligations, being English, does not in fact accurately reflect what both parties had wanted. Then there is a doctrine under English contract law called mistake, which you can use in order to correct or rectify the wording of the contract in order to more accurately reflect the intentions of both contracting parties, or somewhat unusually, in circumstances where one party has made a mistake about what it intended, but the other party knew of this mistake and nevertheless persisted in expressing the contractual terms using the language which bears or reflects that mistake, then again, under common law-based system, the doctrine of mistake can be used to rectify that contract. As it happens, that is an argument which is being deployed in a case in which I am currently involved in which I act for an SOE, a Chinese state-owned enterprise, where we are, amongst other things, our argument is that the contract properly construed, properly interpreted should support our position, but if it didn't, then the doctrine of mistake operates in order to assist us of what we say is the correct interpretation. So that is the one exception I would highlight to the otherwise excellent language point that is made by both Mr. Peng and Mr. Zhang in their earlier comments. The second thing I would say is by way of practical advice, is in order to mitigate the what I would describe as the infelicities of language and expression. In other words, the language that is used to draft the contract does not accurately reflect the intentions of the parties. The practical advice I would give, whether it is to a Chinese enterprise or an Uzbek enterprise or a Russian enterprise who is signing such contracts, is to ensure that there is a bilingual or even a trilingual version of the contract. And in particular, I have encountered situations where, again, acting for Chinese parties, there is typically an English and a Chinese language version of the contract. Now, in many of these contracts, not all, but in many of these contracts, there is a clause in the contract that specifies which language version shall predominate in the event of any inconsistencies. Typically, it is the English language version of the contract which shall predominate. However, if you are a Chinese party or an Uzbek party or a Russian party and you want to ensure, because that's the version you are reading, perhaps predominantly, that the language version in which you operate ends up being an authoritative, if not the authoritative version, then one of the things you would obviously need to look out for is to ensure that this language clause reflects what you want to be the predominant or authoritative language. Now, does that mean that if you have one of these language clauses, which perhaps designate English as the dominant language, still relevant, because to the extent that the Chinese or Uzbek or Russian language version of the contract expresses itself in a manner which is different from how the English language version of the contract is expressed, then you can use the non-English language version of the contract again as a means of supporting an argument based on mistake, which I was just talking to you all about. So, and this is particularly so where the English language version of the relevant clause itself is ambiguous. It's not clear what exactly it means. And in those circumstances, to my mind at least, the non-English language version of the contract, say for example, the Chinese version, would be very useful, not just as an aid to interpretation, to help construe or interpret the contract, but so on top of that, as a means for inviting the tribunal, the arbitration tribunal, to correct the English language version of the contract on the basis of the doctrine of the state. So those are just my observations from a lawyer's perspective as to the role that language plays and how one can ameliorate perhaps some of the harshness that comes with choosing a language which is not the native language of the counterparties who are negotiating the contract in expressing their obligations under the contract.
Thanks very much, Junfei. I can see that this topic is such a big one. Time flies when we get into discussion. I think now we should talk about the next thing that's on our agenda, and that concerns the tender phase of BRI projects. And as we all know, BRI projects and contracts usually have an initial tender phase, and this phase can sometimes have issues. My question to Mr. Peng, perhaps based on your experience, how can parties ensure that BRI projects and tenders are conducted clearly and honestly?
Sorry?
Question to Mr. Peng. How can parties ensure that BRI projects are conducted cleanly and honestly?
Okay. See, compliance risks always exist in overseas transactions. Power China has been adopting a compliance program, which is international standards, conforming to the Anti-Corrupt Act of the UK, and also the New York Convention, which China is also a signatory to it. So, and also the Chinese government, when they put forward this BRI, made it clear that the participants must ensure that BRI projects must be clean projects. So as one of the fully state-owned companies, PowerChina implements its compliance program strictly to make sure that anything against integrity or clean practices in the international markets should be prevented in the first place. And these years, we have been advocating to our staff that if there is a risk of compliance or integrity, business must give way to compliance. There's no choice. This is a policy that every employee, including the management staff, must obey without any compromise. So for this reason, we think there is a guarantee for PowerChina to make sure that the BRI projects which comes into our business will not offend the compliance policies, not only to observe the Chinese government's orders, but also the company's requirements. Charles?
Thank you very much. Could I perhaps invite Mr. Sun to give quick comments on what Mr. Peng has shared?
Thank you, Charles. Actually, have not encountered the compliance risks very often. So I have nothing add on that aspect. But my observation on the tender base is mainly focused on the technical aspects, which is cost problem. So during the tender and bidding phase, one issue that I see frequently happen to Chinese overseas contractors is inaccurate evaluation of the project costs, which leads to them to either of the two extremes. One gave up the bidding. One gave up the bidding because they over calculated the costs, or more disastrously suffering from the huge losses because they underestimate the costs. Inaccurate estimation of the project costs is usually caused by incomplete understanding of the local factors affecting costs, such as the labor costs, natural environment, in particular, extreme weather conditions that disrupted construction works, thereby causing additional costs and construction delay. And also local standards. It's not rare for Chinese contractors to apply Chinese standards instead of local standards in estimating the costs because they are unfamiliar with the local standard. And there's also unfamiliar with the requirement of environmental protection. So all these factors cause the inaccurate estimation of project costs. So that's the problem that I very often encountered, and I think they need to this worth sharing with audience and panelists. Thank you, Charles.
Thank you, Mr. Sun. Let's now talk about the issue of COVID, which we have all together as a world seen through over the past year. Now, COVID has brought about significant disruptions, and it has brought things like lockdowns, vaccine rollouts, and disparities in rules and government measures across different countries, and these may lead to disruptions to projects, to supply chains, to work visas, etc. To the companies, and I would like to invite Mr. Peng to share. Has this been your experience? And if so, how do you deal with such disruptions?
Okay, Charles. To the question, my answer is straightforward. Yes, we do have such experiences in suffering from the pandemic issues. The disruption is actually so extensive and profound that almost all our overseas projects have been suffering from either reduced progress, a forced suspension, or even termination in a few occasions. We've been trying to find out proper solutions to such disruptions. The way available for us to handle such disruptions actually depends very much on the rules and government measures we have to follow in the respective jurisdictions in question. Because almost according to each and every contract, we have to follow such rules and government measures which are almost all mandatory. So without leaving any room for us to choose. Here, I think it is relevant to highlight that the Chinese government has been making it a top priority to ensure the health and safety of the people, and demanded that production must give way to health and safety when they are in conflict. So given such circumstances, things we can do to counteract the disruptions are really limited indeed. That being said, however, it doesn't mean that we wait until the pandemic has come to a complete end. We have been taking measures to either mitigate the impacts of such disruption, such as reallocating or repatriating resources to other projects where such pandemic issues may be not very severe as other places. And also, we endeavor to negotiate with various employers for extension of time to completion, so that we may not be penalized for delay liquidated damages. Or in certain scenarios or jurisdictions, we also try to discuss and negotiate for financial compensations using the provisions in the contract for dealing with changing law. Because law in either the fixed forms of contract or the new NEC, new engineering contracts is broadly defined, covering the newly issued government rules or orders. So in quite a few jurisdictions, we activate this provision to file our claims for financial compensations. And we do succeeded in quite a few cases. Charles, that's all from me.
Thank you very much. John Fei, do you have any just very quick comments on what Mr. Peng has shared?
Yes, I do. Sort of just two quick comments on Mr. Peng's contributions. And the first is that, like him, I have been instructed in at least two cases, again, for sort of Chinese parties involving the effects of the pandemic, typically manifesting itself in claims under the force majeure clause in a contract and or the doctrine of frustration, whereby either it results in a request for a suspension of the time for performance of the contract and or an extension of time. So the reality of what Mr. Peng has described manifests itself even in the disputes which are coming to the fore. The second point I would make is, again, a practical advice for those who are watching, listening to our session today, that if you are, or you are a lawyer advising a client who is considering invoking force majeure clauses in response to local restrictions as a result of the pandemic, then what you need to bear in mind is that there are two ways of doing it, both of which can be complementary. The first is obviously a contractual force majeure clause, but those of you who are thinking of this need to be aware that very often, not always the case, but very often, the force majeure clause itself specifies a specific procedure by which a notice needs to be given for invoking force majeure. The ones which I have seen very often involves a notice being filed or notice being given to the other party invoking force majeure within a fixed period of time from the force majeure event occurring. So that is something which counterparties and their lawyers need to be particularly aware of. The second thing to be aware of is, in addition to invoking the contractual force majeure provisions, there is also an ability to invoke the principle of frustration at common law, or the principle of force majeure at general law if you are based on if it's a civil law system. So for example, under PRC law, that would be an option of doing that as well. So there is the contractual provision that allows you to invoke force majeure, and then there is a general law provision that allows you to invoke either frustration or force majeure as a means of excusing or suspending performance of contractual obligations arising out of extenuating circumstances, whether it's because of an COVID outbreak, a local COVID outbreak, and or more particularly lockdown or other restrictions imposed as a result of such outbreaks.
Thanks very much, John Fei. In fact, on Thursday, we have an event with this UzAW Arbitration Week on the issue of force majeure. So for anyone interested, please be very welcome to join that event. So now, moving away from the pandemic, when working on international projects, Chinese SOEs and businesses around the world, I have a question now for Mr. Zhang. What do you see as the greatest or most common single legal or commercial risk that you would face, and how would you manage such risk, Mr. Zhang?
Thanks, Charles. Like I mentioned before, I think globally, all the international project, oil, from our perspective, that is oil and gas project. The main risks that we've been facing is from three parts. The first part is price fluctuations. All that we all know that the oil and gas price are being listed in the future market. Actually, if we buy a crude from whether from Middle East or from US or from Europe, you have to price down your product as based on the future market, and that price in the future market actually fluctuates every day. So how we can protect ourselves from that fluctuation is a main task that we have to take into account when we negotiate a long-term contract. And I think the based on our experience, that the several ways that we will use that to cover that risk. The first one is we will include a price review clause in our contract, so that if the market change, that we can use that clause to move the price in line with the market price. And the second way that we will use that we will structure a proper price formula so that they can absorb some of the fluctuation. For example, you don't use more element that with the nature of fluctuation in your price formula. For example, you will include some of the inflation rate as a price index, and you use some of the constant. You increase a percentage or a constant in your price formula. That will help you to actually reduce the impact of the fluctuations. And the final way that we will take into account when we deal with the price fluctuation will be dispute resolutions. You have to very carefully to pick the arbitration seat, because price arbitration is a very professional arbitration. It's not like the other kind. So where you choose to arbitrate actually will have impact on your result. So you should be carefully considered. That's the first part. The second part, I think we'll have to talk about the law stabilities. Because most of our project will face that problem, especially in tax issues. And so the way that we deal with that, I think that the most beneficial way is that you sign a privilege contract with the government, so that you can make sure that your rights and your obligation will be stabilized to the level that that in place when you sign the contract. That will not be changed. If there's a change, you just hand out the contract to say, okay, that's the way we agree. You cannot change that. That's the way we've been used in our several our projects. I think that the second thing we need to think about is that you can include you can include law change as a part of a force majeure event. If that happens, you can call force majeure event, but you have to be very careful that force majeure event only can call on the benefit of the foreign party. I mean, you have to make sure that the other party, the local party, cannot enjoy that benefit. Otherwise, it may cause problems for you. I think the last point is a compliance risk. Okay, I think everybody know that currently the sanction issues and all the anti-corruption issue, the money laundering issues are actually the main risk that we've been facing, especially during this period of time. This risk is actually increasingly incurred. So normally what we deal with that is, first of all, when we start a project, we will do the due diligence and the KYC process, make sure there will be no non-compliance elements being involved in the project. The second thing that we will do is that we will clearly and carefully define compliance clause in our contract, so that when there's some situation happens, we can rely on that. We can rely on that clause to either suspend the performance or terminate the contract. So I think especially something I think worth mentioned here is whether we should include the compliance risk in the force majeure clause. And to our experience, we at least from our perspective, we will not include in force majeure clause. We will rather to include that as a kind of right. That means if there are some events happen which will cause us a risk of breaching that compliance obligations, then we will have a right to suspend or to terminate. The reason not being included in the force majeure, because just like the QC said, the force majeure do have a very, very strict requirement. You have to comply with before you can enjoy the relief. You have to be noticed, you have to mitigate your loss, and you have proof that something happened, and that event, the so-called force majeure event have already impacted your performance. Then you have to improve lots of things. You have to prove evidence, and if you just any short of those evidence, you strike out from enjoying the relief of force majeure. So it's very risky. It's very risky to include compliance in the force majeure event. So we normally will actually have an independent clause to say if there's some risk, then we have the right to do so. And if you have a right to do so, that means you don't have to justify anything. As long as things happen, you have rights. So that's the risk we've been facing and how we deal with the risk. Charles.
Thank you very much, Mr. Zhang. Could I invite Mr. Sun and John Fei to add just very brief comments, perhaps within 3 minutes each, on this topic of risk to international projects. First with Mr. Sun.
Thank you, Charles. I have nothing to add on the commercial risks, but I want to share something about the politics risks. Actually, many of the dispute resolution cases that I personally work on arise of policy and political risks. So I want to share two types. The first type of risk is the lack of policy continuity. Policy continuity is particularly important for long-term energy and infrastructure projects. Both key aspects of BRI initiative. The economic calculation of the investor often depends on the policy and the promise made by the government of the host state. When there is a change of the policy and the project could become unavailable. For instance, we're working on a oil and gas dispute that involved a Chinese SOE and an African host state. Like many other oil and gas projects, there is a contract between the SOE and the local government on sharing costs and profits. After more than a decade of successful operation, the government of the host state is now demanding far-reaching comprehensive labor, environment, health, and safety reforms. Problem is, these new policies lead to huge costs, rendering the project unprofitable unless cost profit sharing mechanism is adjusted accordingly. So the most common tool to reduce the type of risk are stabilization clauses. And there are often exceptions for these clauses, particularly in relation to health, safety, labor, and environment protection. Sometimes these exceptions are too broad and effectively render the whole stabilization clauses toothless. So hence a careful designed and effective stabilization clause is definitely something that I would advise clients to get in long-term energy and infrastructure projects. The second type of a policy and a political dispute is an intergovernmental dispute, i.e. the dispute between different government and government fractions of a local government. If unfortunately caught in the crossfires, investors would be in an awkward position. In one case that I'm working on that involve infrastructure project. So one ministry supports the project and another ministry is against it. So both ministries have their own supporters within the ruling party and eventually leads to the project being cancelled. So that's my observation. Charles.
Thanks very much. John Fei, 2 minutes to you.
Yes, I just want to follow up on what Mr. Sun said about stabilization clauses and introduce another mechanism which I have encountered in cases to address political, economic, and other risks. I acted in two different or a pair of arbitrations, each for SOE clients, involving share sale and purchase agreements, whereby my SOE clients had entered into a contract to purchase shares in a company for investment purposes. And one of the common features of both of these cases is that there was, as is often the case in these contracts, a material adverse change clause, MAC clause, where depending on the way in which the MAC clause is worded, it covers a smorgasbord of different risk factors, whether they are political or changes in the law and regulation, government approval, changes in significant changes in the commercial circumstances of the buyer or the seller concerned as a precondition to completion of the share sale and purchase. So what tends to happen sometimes is you've got a share sale and purchase agreement, an SPA that's signed, and then there is a period before the shares are completed or the acquisition is completed. And what the MAC clause is designed to do is it is designed to cater for any possibilities in changes in circumstances which might affect the economic rationale undergirding the share sale and purchase agreement to begin with. So that's a contractual mechanism that can be and is typically inserted into contracts, not just share sale and purchase agreements, but contracts in general, in order to cater for risks, whether they are political, economic, legal, or otherwise.
Thank you very much, John Fei. I want to leave a little bit of time for questions. I understand that there are people in the audience who have questions, but I will leave a few minutes for you. Before that, I just want to talk about mediation, because mediation is something that's very much in the Chinese tradition, that's in favor of non-adversarial methods of dispute resolution when disputes arise. However, not all countries in the world follow this tradition, and I would just like to ask a quick question to Mr. Peng. Can I ask what has been your experience in resolving disputes through cross-border mediation? Mr. Peng, please.
Right, Charles. Before I answer your good question, I must say that you command the essence of Chinese tradition. Yes, you are absolutely right that we Chinese value harmony and rapport very much, and thus are very reluctant often to confront partners in particular. But this has been changing, according to my experience, since our open door policy. Bit by bit, more and more Chinese companies realize that one hand can not clap, and that harmony needs the efforts of all parties to a contract to avoid confrontation, which unfortunately is often inevitable. I mean, a confrontation or disputes. So, so far as I'm concerned, it is not whether it is adversarial or non-adversarial methods of dispute resolution that matter, but their efficiency in resolving disputes, whether the determination, opinion, or award is binding, or even whether the resolution will bring an end to the disputes. Of course, we also take into consideration the cost effectiveness of such a resolution mechanism. So for all these reasons, Power China prefer a fast-track dispute resolution mechanisms, which is binding, efficient, and final, which we think if you could put a DAB or DB mechanism in the contract, which we think will do very much favor to the performance, to the parties, to the contract. Of course, if a PPP project is concerned, sometimes we were recommended exit forum or BIT, bilateral investment treaties. But both of them are very tedious and time consuming. I mean the proceedings. Some of them may take years or ages to be concluded. So in quite a few investment projects, we successfully introduced fast-track dispute resolution mechanism to the PPP contracts, like the concession agreement or implementation agreements. They take very much similar a form of dispute resolution mechanism in the FIDIC forms of contracts. They are ad hoc, not standing board. So in some cases, if the issues are very technical, we also establish expert determination mechanism for a quick solution to resolve the disputes. So this is the experience and the thoughts I would like to share. Charles.
Thank you very much, Mr. Peng, for your insights. Well, this has been a very fascinating 1.5 hours with all of you. Just before we end this session, I believe I would like to have to give the chance to someone from the audience. I would like to give this chance to someone from the audience in Tashkent to ask one question to any of the panelists. We only have time for one question. It's my regret about this, but please. I believe there were people who wanted to ask earlier on. So if someone could hand the mic over to that person, or anyone else who wishes to ask.
Yeah, yes, it's working.
I'm here.
Well, thank you very much for
Thank you
this
so
wonderful panel. BRI, it was always my passion during pandemic to study and really come up with research. So I came up with a book I would like to share. Maybe you find out maybe somewhere. It's not for advertising, but it's just to bring the thoughts together. Well, you knew when you went.
Sorry, it seems to be breaking up. So sorry for the interruption. Yes, please. You may continue. Mm.
Yes, thank you very much. I'm sorry for this. My name is Jamal Shakuni. I had the opportunity to write about this BRI project during the pandemic. Now, everybody knew from 2013 when you start up the initiative that is crossing 65 countries with a different culture. It's amazing to know that you're already covering 47 countries. But what about standardization of the contract? Why didn't you start like what the World Bank had on the Pink Book, for instance, and add up what other people have finished, like adjudication, introduce adjudication, mediation, and emergency arbitration in the standard format? So at least you can have a fast track mechanism that everybody knew about it from the day one, that you have top experts from these countries to be involved in the adjudication. And then when it comes to mediation or comes to later on for emergency arbitration, you have it all sorted out from day one. And I know that 47 countries to be in is not just step in and open office. It is definitely doing a lot of training, finding out a lot of on the local experts, and try to utilize what expert you can get from these BRI countries, so you can really mitigate all the risk you're talking about, the cultural differences and the, the other risks, the political, because end of the day, what really matters is people know the benefits of the BRI projects. It is it is new form of globalization, but it is a win-win situation. So you need to show it all in a good standard format from day one, educated, trained, and at the same time having the team involved, identify from day one. What's your take on this? I'll leave to Charles or project manager. Thank you.
Mr. Sun, or any of the panelists, do you wish to answer?
I want to touch very briefly about efficient dispute resolution mechanism, which the gentleman just mentioned, that emergency adjudication is kind of a different layer of dispute resolution. I want to mention two things. One is the expedited arbitration. That actually UzAW Working Group 2, we just finished the expedited arbitration project, which is going to be finalized next year, and it's going to be published. And then the second one is that the UzAW Working Group 2 is going to probably, very likely, that we're going to do another project. It's called, example, adjudication, which is originally originated from UK, and probably I think my learned friend we know that it's very useful too to solve the dispute resolution, solve the dispute at a very early stage in a very efficient way. That's what I want to share. Thank you.
Okay, well, thank you very much. Again, It's a pleasure to have every one of you here together with us, both in person as well as online. It's a pity that we don't have time for more questions or to get into the discussion about the question that was just asked in greater detail. But that's because of time constraints. I want to say thank you to all the panelists for all your hard work and your agreement in attending and giving up of your very precious time to join us over here on day 2 of the UzAW Arbitration Week. If anyone of the panelists, no, I'm sorry, if anyone of in the audience wishes to be in contact with any of us, I'm sure you can reach out to the Secretariat of TIEC, who I'm sure will be able to make the necessary arrangements. And well, I would say look forward to the rest of the events of UzAW Arbitration Week. And thank you very much to everyone. It's been a pleasure.
Thank you. Thank you,
Thank you very
Charles.
much.
Thank you, everyone.
Thank you.
Thank you. Bye.
Goodbye.
Thank you very much, Charles.
Bye-bye.
Thank you.
Thank you very much.